specifically, a little bio. I was born and raised in Peru until age 15 when I moved to the US. And I went to, for undergraduate degree, I got a bachelor's in mechanical engineering from the City College of New York. Then went to work for several years for Procter and Gamble as an engineer in the Pampers business, so developing
Mhm.
diapers and processes to make diapers at really, really high speeds. And then did my MBA and then law school. And as an attorney, I worked for several years at a law firm that did nothing but intellectual property, a firm that's been around for, I don't know, 175 years or so. And then for another 12 and a half years, I worked as in-house counsel for a big multinational Sweden-based company, and I was responsible for the all the IP for North, Central, and South America. And I left that in December of 2023 and started my firm, which I named the Patent Excel Law Firm. And I've been doing that on a full-time basis for about 8 months now, and I couldn't be happier.
Oh, it's great. I mean, it's plenty of experience for the business that you're in, for the industry, for the specificity of the side of the legal um, aspect that you're in. So definitely great to know you, great to know a little bit about you. So let's dig a little deep on. First of all, let's you mentioned that you went from Peru to New York. So I mean that's a tough place to navigate, especially I'm assuming especially for a newly arrived migrant. What were some of the biggest challenges you faced when you first arrived, and how did you manage to not only adapt but thrive in that fast-paced environment?
Sure. Well, I'll tell you what, a lot of people, when they hear that I moved here at age 15, right away they assume that, oh my God, that is a rebellious age. You're a teenager, you're leaving all your friends behind. It must have been really, really difficult from that standpoint, a social standpoint. And the reality is, no, not quite. I had a lot of friends and everything, but I was closer to my family, and the entire extended family moved over the course of maybe 5 to 8 years. So the entire extended family, uncles, aunts, cousins, grandparents, everyone moved to New York. And so I didn't have anyone to miss back home except for some distant relatives and certainly friends from school and other friends from the neighborhood. The biggest challenge, if anything, was probably language related. And you're freshly arrived and you're an immigrant as well, so you probably experienced something similar where you are not understood by others, and sometimes people can not treat you the right way when they can't communicate with you. And I experienced a little bit of that, especially taking my mom to hospital appointments and then not being able to communicate and being mistreated as a result. But that stopped within a few months. I gained fluency quite rapidly, and as a result of that, that stopped. And and as far as the being fast paced, yes, New York is very fast paced, but that was my understanding of America. That is what I knew. I didn't know anything else. It wasn't until I graduated from engineering school and I moved to Cincinnati, Ohio, where suddenly I realized, oh, okay, there's a difference here. If anything, my the fact that I spoke at that point, I spoke English with a very heavy Queens, New York accent got in the way of my forming relationships with people because I came across as very aggressive. But that was just the way that I talked, being a New Yorker. But, having spent 17 years in Cincinnati, my accent morphed some. And now the last 13 years in Philly, I have no idea what I sound like. But certainly, going back to the original question, language is no longer an issue. And I guess you perceive that. And no, I'm happy to be an American. I'm happy to be in this country and having, my children be born in this country as well.
Yeah, no, you're right. You're right. You bring up a good point. I mean, language. I came to the U.S. a little younger than you. I was 10 when I came to the U.S. So, yeah, you get a little different treatment from students, I mean, at that age, they're not used to it, so they may treat you differently just because of it. But hey, it's a great thing that you overcame it, and yeah, it's a little slower in Cincinnati than it is in New York. I agree.
A little.
Well,
Yeah.
now you mentioned, I mean, your education background, it's fascinating. So you've had a fascinating career journey, earning a degree in mechanical engineering, and then eventually becoming a prominent intellectual property attorney. What sparked your decision to switch from engineering to business and then to law? What were those defining moments that uh, push you in that direction?
Yeah, that is a great question, Rogelio. I thought my entire childhood that I wanted to become an engineer because I was always really good at science and math and loved that stuff. But once I started working as an engineer, especially for a big multinational company, I realized that I wasn't doing much engineering. I was doing more management of outside consultants that were doing a lot of the actual engineering work that I was trained for. So it was a little bit of a disappointment. But at one point, I found myself and my family being involved in litigation over a house that we purchased that had some defects that were not disclosed to us. And we ended up filing a lawsuit. And every time I saw a motion filed by the other side or by us, I loved it. I said, "Oh my God, this is fantastic. Look at the strategy of what is being done." I remember telling my now ex-wife about it, and she was freaking out over what the other side was saying. And I said, "No, no, no. Listen, this is why they're doing it. They're trying to establish this precedent, blah, blah, blah." So that sparked my interest in the law generally. And and then I discovered patent law. And then I realized that I could use my engineering as a requirement of becoming a patent attorney because you need to be an engineer or a
Okay.
scientist to be allowed to take the federal patent bar. And I said, okay, well, you know what? Maybe I should go to law school and become a patent attorney. But unfortunately for me, I let someone talk me out of it. I was talking to somebody that said, "Oh no, you've always excelled at school. You know, you were always number one. You're finally going to fail because you have no idea how hard it is, how much reading there is to do, how much work. Do not do it." So me, reacting to somebody's constructive feedback, I said, "Thank you so much. I really appreciate that." I said, "I'll settle then for my MBA." So then I decided to go to business school. But halfway through it, I remember having an experience where the professor, it was a finance class, and we get to a point of calculating some type of ratio. And the
Mhm.
math ended up being one fraction divided by another fraction, which to me, as an engineer, was a no-brainer. And all of these people around me who they were sold to us as look around you, these are the future CEOs of companies in America. These guys were freaking out saying, "Oh my God, how do we solve that, professor? A fraction over a fraction." Then I said, "Who in the world am I surrounded by here? It's a bunch of idiots." And I said, "You know what? No, forget it. I need to go to law school. I don't care what happens." And I figured, I already started this, might as well finish. So I waited until I finished the MBA program, and then I applied to law school, and no regrets. And I did quite well there also. And so now my only regret is not having, I don't regret having done the MBA because I learned a lot from a business
Mhm.
perspective, which now helps my clients. But, there's a little bit of an element of regret in not having started law school
Sooner.
sooner. All right. But it is what it is. C'est la vie, as they say in French. And I've been doing intellectual property law for almost 2 decades with no regrets.
Oh, that's great. That's a fascinating story. So it's amazing that you stuck to your guns. So I mean, you didn't switch midstream, but you finished your MBA and then went on to get your law degree. Kudos to you on that side. Now you mentioned, I mean, with your early career that you started with Procter and Gamble, you just a company that's known for global influence. How did your background as an immigrant help you navigate and succeed in such a large multinational organization?
I don't know that being an immigrant brought anything of value as you may think of it. I mean, certainly I had my own perspective of viewing things, but not as an immigrant, but maybe just as an individual. I had my own way of looking at things. The reality is at big companies, and I don't think Procter and Gamble is the only one. They, I know they went out of their way to avoid hiring experienced people. They only took people right out of school to morph them. I don't want to say brainwash them, but to
Mhm.
morph them into a specific Procter and Gamble way of thinking, which now in hindsight I appreciate really. It actually I think I owe a lot of the way that I think right now to what I learned back then. And there's an entire community of P&G alumni that we meet regularly, and we all have that same mindset. And so I don't know that being an immigrant necessarily influenced my way of thinking. Maybe it did without my realizing it.
Mhm.
Um, but you know, what can I say? I had a good time there.
Oh, that's definitely good. Very good. How often do you guys meet with your PNG alumni?
I think the meetings are, I didn't say I necessarily participate. I think I've participated on a few webinars. I
Okay.
get I get invites via email. I know they have conferences also in person. I've never participated in one of those, but it's still good connections that I have through that network. If, now thinking back to the last question, I mean, if there was one thing being an immigrant that influenced my career at P&G is perhaps this hunger that I had as an immigrant for realizing the American dream and this hunger to not stop with one degree and wanting to just keep going with my education, and which is why I ended up wanting to study something like I said at first law, but then settling for the MBA and then eventually law. I didn't want to stop, and it's a hunger that many immigrants have that I unfortunately don't see in a lot of the native um, American-born
Mhm.
citizens, that because they haven't experienced poverty, maybe they don't realize how good they have it, right? How good it is, and what the sky's the limit here in the U.S. And they didn't have to deal with same challenges that I did, and so maybe that hunger is what drove me to keep going. But anyway, so that's that.
Very good, very good. So, and listening to that experience, and now you are entrepreneur, so you're starting your own business. Let's talk about that. Let's talk about your uh, balancing your expertise and legal strategy to solve for your clients uh, that you're currently taking on. What is it that you're looking to do for them, or what is the solutions that you're providing to some the clients that you're dealing with and that you're looking for?
Yeah, that is an excellent question. I normally see myself as a counselor to strategically try and reach or allow my clients to reach their goals, their business goals. So what is it you're trying to achieve? So basically, someone comes to me and says, I've invented something and I want to get a patent on it. My next question is going to be, why? What is it that you're trying to get out of that patent? Right. And now over the years, I've had people that said to me, I, yeah, I have an invention. I want to get a patent. And when I went back to them and I said, listen, based on my investigation of this, you could possibly get a patent here, but it's going to be of very little value. It's going to be so narrow because that's all that is available, that it's probably not worth your money. Save your money. Don't do it. But they pushed back because they said, no, I want to get it because it's bragging rights to be able to tell the world and my family that I have a patent. And if and that is a valid business, that's a valid goal, maybe not a business goal, but a goal. But so long as I understand what it is that the client wants, then figure, okay, so they don't care to get a patent that is as broad as possible, then I'll approach it in a certain way. But if a company comes to me and says, I've invented something and then my entire business is going to depend on whether or not I get a patent on this, then I approach it a bit differently. And we always discuss with clients what the business side of things is. And I know what type of expectations they have and what they think they're going to be doing with the patent or even the trademark, right? So what is it? Why is it that they want to register a trademark? Is it because they want to block competitors? Is it because it's such a fantastic logo or fantastic creative name that they want exclusive rights to it? Or is it because they're trying to accumulate assets, and trademarks are assets, just like patent are assets, that they can then build a portfolio around and be able to make the company more marketable to sell to
Interesting.
others. And that's fine too. But the business side of things and explaining to people, not in legalese, but in business terms that allow them to make sound business decisions, I think is of great value. And that is one reason why I don't necessarily regret having learned what I learned as a getting an MBA, right? As a bit with the business
Mhm.
education that I have. But at the same time, with inventions, people tend to appreciate the fact that I'm very knowledgeable about technical stuff. And now some technical stuff I've never worked on, but I just know from basic knowledge of science and basic understanding that I know from my engineering education and from being old, right? You get exposed to so many things, and people appreciate that understanding on technical things.
Very good. You know, we'll get back to you touched on a couple of points about we'll get back to I want to ask a question later about entrepreneurs versus big corporations, but let's go back a bit. You used the word broad, meaning when you're doing a patent, when they're applying for a patent, if it's not broad enough, that it's only a certain segment, but they wanted it for bragging rights. I get it, but let's talk about when you're applying for a patent, broad to specific. And I know you were involved with a Supreme Court case, a landmark case that involved that broadness of an invention where somebody said it's too broad, it's limiting us. And talk to us about that. Why does a business have to take a look at that?
Yeah, well, in this case, the client that owned the patent was interested in stopping a competitor from copying a feature on their product. They had a very, very specific feature that they thought was of value, which was the essence of the patent that they had. And they chose to go after them because that competitor was taking advantage of what had been developed by this client. And they decided to file a lawsuit. Now, a lawsuit in the patent field is very expensive. It's very lengthy as well. It's very, very complex. It has many different elements to it. And in this case, the other side argued, and successfully initially, that my client took too long in bringing the lawsuit. And they said, you are stopped, not stopped, but as stopped with an E, from doing anything because of latches and because of equitable estoppel. These are doctrines in the legal field that I'm not going to get into, but bottom line, they were arguing, you guys took way too long in bringing this lawsuit forward to us. And now look, we've invested all of this money, all this capital in making equipment to make this product and all the marketing dollars, et cetera, relying on the fact that we thought you didn't care to enforce your patent because you took too long. So you we should ask the court to prevent you from going after us as a result. So they filed a lawsuit. They succeeded
Mhm.
initially, but then my client fired back and eventually appealed to the Court of Appeals at the Federal Circuit. That was unsuccessful, and then to the Supreme Court. And it is at the Supreme Court where we prevailed as a result of a similar decision that had come out just within the prior 12 months in the copyright field that had a very similar tone, very similar arguments. It was also based on latches and whether or not a specific period to bring a lawsuit is within the statute. And that was all encompassed in that copyright case, which was based on a movie that you may have seen. I've never seen it, but Raging Bull with Robert De Niro, where he's a
Mhm.
boxer. Yeah, it was a copyright case around that. So a decision comes out by the Supreme Court that sides with the plaintiff saying, no, laches doesn't apply in the copyright realm because of this one statute. And it was lucky timing for us because we had that same argument here. And so basically the court's hands were tied when we said, hey, this is no different from copyrights. And they had no choice but to give us the right to bring that case and to have the case heard at the Supreme Court. And the decision had to be in line with that. They couldn't take one position for copyrights and another one for patents. So in fact, the sole dissenter in the copyright case had to also be the sole dissenter in the patent case. So by then, Justice Scalia had already died and not been replaced. So there were only 8 justices, and the case ended up being 7-1, total 8 justices. So it was a 7-1 win. But that was just on whether or not latch is applicable to this type of case. But then, of course, that was remanded back to district court to continue with the infringement. But then the parties settled, and then
Yes.
obviously the settlement terms cannot be disclosed here. It's confidential,
That's great. I
but
mean, it's good
that was the end
to,
of it.
yeah, great to know that. I mean, looking at the expertise that you bring from the business sense and from the mechanical engineering, which needs to be done. So you have that. That's a great contribution, and the ability to defend a client like that. That's a great experience from your side. So having looked at that, and you've defended a corporation, big one, and what do you prefer to deal with? Smaller businesses, big corporations? What's that? I'll call it, what's that sweet spot for Ramon and Pat in Excel? Where does he want to focus his time? Not free time, I'm sure.
Right. Well, I have to say, from a business standpoint, bigger clients are always better because they have deeper pockets, right? So they're not going to hesitate when it comes to spending an additional couple of $1,000s to file something. That is preferred from that standpoint. But what I find rewarding is actually helping the smaller companies and entrepreneurs and up to medium-sized companies that require a lot of guidance. People that perhaps don't have their own intellectual property attorneys, or in some cases, they don't have even an attorney in their staff, and they need a lot of guidance from different standpoints. Maybe they don't need that. They don't even know that they need to talk to an IP attorney, or who else besides an IP attorney they need to talk to, or they may be making the wrong assumption that an IP attorney is who they should be talking to. And here I can say, well, no, you don't need me, but you need someone that specializes in regulatory matters, or you need someone that specializes in something totally different, the
Mhm.
formation of a business, like LLC formation or corporate formation and such. And I will gladly put them in touch with those people. It's all about doing the right thing for the business. And even if in the end it is less money for me because I may just turn away a client because I'm not the person that they need, or maybe it is not the right move to do some type of filing that is IP. I still find it very rewarding because I have helped a human being, a fellow entrepreneur, to be successful. And with karma, or if you want to call it God, eventually I know it'll come back, and I'll be fine.
Mhm.
So I find it more rewarding the smaller that they are, even if they don't have the deep pockets that the big corporations have.
When does, and you mentioned like that a entrepreneur may visit a IP attorney, but you'll be able to guide them into the real law, or lawyer that they should be involved with. But when should a business owner or entrepreneur meet or think about getting together with an IP attorney, or having an IP attorney, such as yourself, guide them in what they're doing?
The earlier the better, because it may be a case that it is, in fact, too early to do anything, such as if a business says to me, yeah, we're in the process of creating a logo, or coming up with a name for the business. So it may not be the right time to file anything to protect it, to protect the trademark, but I may still be able to give them a little bit of guidance. And in most cases, free of charge guidance in saying, okay, maybe you will come up with a list of 3 or 4 different names you're considering, let me do a quick knockout search, make sure that those names, if applied, if used, are not going to get you in trouble with somebody else that may be using that name, whether or not that name is registered as a trademark. There are what is called common law trademark rights. So even if someone doesn't actually file a registration on their trademark rights, they still have under the common law some trademark rights, which are limited, very limited compared to something that is registered. But nevertheless, they do exist and they may block you in certain geographies. And when it comes to companies that develop new products, new processes, who are in the business of constructing something, definitely the earlier the better, because I need to be able to tell them not to disclose or even provide them the right tools to disclose their invention on an as needed basis and
Mhm.
maybe through confidentiality agreements and such. Because the problem with patents, which doesn't happen with trademarks, is that once they disclose their invention in a non-confidential manner, even if they tell their cousin, hey, I invented this, then the clock starts ticking. At least in the US, the clock starts ticking, where now that disclosure starts the clock, giving you exactly no more than 1 year in which to file for patent protection, or else you lose novelty. Now, that's in the US, which gives you that what they call a grace period of a
Mhm.
year. When it comes to the rest of the world, I don't think there's any other country that has the same rule as the US. In every other country, if you ever are thinking of protecting your invention in Mexico or in Colombia or in China, once you make that disclosure in a non-confidential manner, you're done. You're fried. You've lost a novelty. So it is in your best interest to keep that as secretive as possible from the start. And yeah, I've been approached by companies that said, yeah, I want to patent this. And once I start digging into it, who have you told and under what circumstances? And I know they've already disclosed it. I'll, I'll be the bearer of bad news, but it's better than that they get the news now than later, because there may be some unethical attorneys out there that will say, well, I don't care, don't tell anyone. I'll go ahead and file for a patent. And it is an unethical thing to do. It is committing fraud with it on the USPTO. And eventually, if that patent ends up in litigation, the fact that that was disclosed in a non-confidential manner will come to light, and the party,
Mhm.
your client that holds that patent, will unfortunately lose, and they'll lose their entire investment in the patent. And so the earlier the better, um, from many different instances. You also, if you already have a trademark that, or a brand that it's already defined and it's ready to be trademarked, the earlier the better as well, because you could be blocked if you wait too long by common law rights of somebody else that starts using your mark
Mhm.
and even register it before you do.
Right. Well, we gotta get early, maybe Tuesdays with row, we gotta start doing that.
Sure, sure, I've thought about it.
Very good. Now, I appreciate, again, Rowan, appreciate your time and the insights that you have for us. What other advice do you have for the business community out there?
Be very mindful of how expensive litigation is in the United States when it comes to IP in particular, and the fact that this is a very litigious country. So talk to an attorney, whether it's an IP attorney or a business attorney that hopefully will and say, here, I know someone that does IP, and talk to them. Do your homework, do the registration or consultation with an IP attorney as early as possible. Do not simply start using your trademark and wait until you are faced with a potential challenge by somebody, or where you want to challenge somebody else that has started using your mark, because at that point your chances are very limited. uh, and it's going to get really expensive if you then have to challenge somebody in court, or even a court within the USPTO, which is the TTAP they call it. Um, do it all up front, even spend the money, which isn't much really, to protect whatever creative
Mhm.
assets you come up with, or even through copyrights. Do it up front. Don't wait until you want to react to something that has happened because it'll be really expensive and inconvenient, and it'll give you a headache if you wait.
Well, great words of wisdom there. Thank you again. If anybody wants to schedule time to meet with Ramon, I believe his QR code is on his back screen there, but if not, his information will be on the video. We'll post this. It's on Facebook Live right now, but it'll be posted later on to the YouTube channel, as well as LinkedIn. So we'll have Ramon's contact info so you can schedule a consultation with him as far as your products, your line, your copyrights, whatever you're looking for to really make secure your business and the assets of your business. Again, thank you much, and we'll see you next week.
Thank you, Rogelio.